names of the torts weren't intent. The names of the torts were battery, false imprisonment, trespass to land. Unfortunately, we must have a shortage of names in the law of torts because there's a tort that we're going to talk about now which happens to be called negligence. Now, you got to be real careful. Are you talking about negligence as a basis of liability? Because, you know, negligence is a basis of liability for many torts. We'll see later on it may be a basis of liability for defamation. It may be a basis of liability for misrepresentation. It may be a basis of liability for nuisance. It may be a basis of liability for many torts. But now we happen to be talking about a tort called negligence, which frankly I think would be better called negligent infliction of physical injury, or negligent infliction of mental injury, or negligent infliction of property damage, because that's really what the tort called negligence is all about. So remember, negligence has two meanings. Negligence is a basis of liability of many different torts, and it also happens that there's a tort called negligence. And like all other torts, the tort called negligence has essential elements. The tort called negligence has the essential elements of, first, negligence. And you know, that gets very confusing. And we already know that negligence itself, as a basis of liability, has two essential elements, a duty of reasonable care and a breach of that duty. So let's say that the first two elements of the tort called negligence are a duty of reasonable care and a breach of that duty. And the second two elements are proximate cause and damages. Remember at the beginning of the tape I said that in most tort problems we'll have to consider three factors. The first is basis of liability. The second is proximate cause and damages. And then we said the third factor is affirmative defenses. The tort called negligence has four essential elements. The first two essential elements relate to the basis of liability, a duty of reasonable care and a breach. We call that negligence. The second two elements are the second factor in a tort problem, proximate cause and damages. So let's talk about proximate cause. Proximate cause is a legal expression that has a very special legal meaning. When we talk about proximate cause, the question that we're trying to answer is this: was defendant's conduct a proximate cause of plaintiff's harm? I'm going to say it again, and notice I'm placing a heavy emphasis on the word A. Was defendant's conduct a proximate cause of plaintiff's harm? And the reason I'm putting such a heavy emphasis on the article A is because any harm can have more than one proximate cause. And it's important for us to decide whether the defendant's conduct was a proximate cause. It doesn't have to be the only one. And if you remember that, some of the proximate cause problems that confuse your classmates won't confuse you. I'm going to go. And here's something else that'll help you avoid confusion. What we mean when we say proximate cause is really a combination of two factors, which can be called factual cause and legal cause. Proximate cause is a combination of factual cause and legal cause. Let's start by talking about factual cause, and I want to let you know factual cause is also known by other names. Factual cause is sometimes called actual cause. Factual cause is sometimes called physical cause. Factual cause is sometimes called cause in fact. Factual cause is sometimes just called cause. When we say defendant's conduct was a cause of plaintiff's harm, what we really mean to say is a factual cause of plaintiff's harm. How do we decide whether the defendant's conduct was a factual cause of the plaintiff's harm? The first and most important rule, when I say most important, I mean the one we apply most often, is the rule that has come to be called the but-for rule. Because 90 or 100 years ago it was convenient and comfortable to say defendant's conduct was a factual cause of plaintiff's harm if plaintiff's harm would not have occurred but for the defendant's negligence. But you know, we don't really use expressions like that in modern English, and I think it's a shame that that expression has stayed with the law. All it does is confuse. So I'm going to replace but for with the word without. We'll still call it the but-for rule, but let's state it this way. Under the but-for rule, defendant's conduct is a factual cause of plaintiff's harm if plaintiff's harm would not have occurred without defendant's conduct. That's the most commonly applied rule of factual cause. I'm going to give you an example. This example may sound a little bit like a case you've read, but it isn't. Be real careful with the facts I give you. And by the way, that's a good idea. Whenever you hear an example or a problem or you take an exam, even if the facts look a little bit familiar, you better study them and make sure you understand these particular facts, not the facts they happen to remind you of. In my hypothetical, John is minding his own business, walking through the woods, when defendant number 1 fires a gun in John's direction. And right at that same moment, defendant number 2 fires a gun in John's direction. Each defendant strikes John with a bullet. John is struck by 2 bullets. One bullet causes John to lose a pint of blood. That's the bullet that was shot by defendant number 1. The bullet that was shot by defendant number 2 also causes John to lose a pint of blood. John has lost 2 pints of blood, and John dies. And the medical experts say that if John had lost only 1 pint of blood, he would have lived. But having lost 2 pints of blood, his death was inevitable. Question: was defendant number 1's bullet a factual cause of John's death? Hey, remember the but-for rule? Defendant number 1's bullet was a factual cause of John's death if John would not have died without that bullet. And the medical experts tell us that if John had lost only 1 pint of blood, he would not have died. So, he would not have died without defendant number 1's bullet. Defendant number 1 was a cause of John's death. Hey, wait a minute. Defendant number 2's bullet caused John to lose the other pint. Well, defendant number 2 was also a cause of John's death because John would not have died without that bullet. Under the but-for rule, as you can see, there were 2 causes of John's death. The but-for rule works most of the time, but there are special situations in which it doesn't work. Maybe you read a case about a fire. 2 fires. One fire was started by a negligent defendant, and the other fire was started by lightning. The 2 fires were burning in the same general direction until they came together and formed one big fire, and the big fire burned down the plaintiff's house. The plaintiff sued the negligent defendant who started the fire. And the negligent defendant said, hey, even if I hadn't started the fire, the lightning started a fire that would have burned you out anyway, so even without my fire you would have had an injury, and therefore my fire was not a cause under the but-for rule. In that case, the court applied a different rule, which has come to be known as the substantial factor rule. And the substantial factor rule says that defendant's conduct was a cause of plaintiff's harm if it was a substantial factor in producing that harm. And it was a substantial factor in producing the harm if it would have produced the harm all by itself. Remember, in this case, even if there had been no lightning, defendant's fire would have burned down the plaintiff's house. Since it would have produced the harm, even if it had been all by itself, it was a substantial factor in producing the harm, and therefore a cause of the harm. Hey, let's go back to those 2 crazy defendants that are shooting guns in the woods. Defendant number 1 shoots a bullet. The bullet strikes John and causes John to lose 2 pints of blood. Defendant number 2 fires a bullet which strikes John and causes John to lose 2 pints of blood. So John lost 4 pints of blood, and poor John dies. Remember the medical rule that said 2 pints of blood, kill him? Less than 2 pints of blood and he wouldn't have died? Well, defendant number 1's bullet caused John to lose 2 pints of blood, so it would have killed John all by itself if it had been left alone. That makes it a substantial factor in producing John's harm, and that makes it a cause in fact, or a factual cause, or an actual cause, or a physical cause of John's harm. Bullet number 2 caused John to lose 2 pints of blood, which means if it had been left all to itself, it would have caused John to die. So bullet number 2 was a substantial factor in producing John's death. and that makes it a factual cause or an actual cause or a physical cause of John's death. So now